welcome to Hill and Ponton's live Q&A. I'm Shannon Brewer, and with me today is Ursula Mecabe, and we are here to answer your questions. So let's get started.
I'll take the first one because you just asked. Okay. All right. How long does a judge appeal take? So I am assuming that you're meaning when you file a board appeal, not a CAVC appeal. And I think this question really is, it depends. It depends on which lane you go into, whether you go into the direct review, the evidence submission, or the hearing lane. It also depends on whether or not you waive the additional time to switch appeal lanes. And it also depends on whether or not you have any reason to advance on the docket. I would say for, just a regular direct review, I think you're looking at about a year. Evidence, a little longer, maybe 2, and hearing, I don't know because I don't really do those ones, but I'm assuming they take a lot longer. But if you do have a reason to advance on the docket, I'm seeing about 6 months, 6 to 8 months. So it just depends.
That sounds about right. And if you are taking it to court and that's what you mean, it really depends on whether they settle it out early or not. So they have a mediation conference early in. If they decide they've agreed at that point, then it's a matter of months. If you're going to have to brief it all the way out and wait for responses from the VA, et cetera, then it's more like 18 months to 2 years. Okay, this next one is from Jacob Samuels. Hey, husband is rated at SMC M.5. Both his knees got increased to 50% apiece. Does he go to N or N.5? I would need to see all of his ratings really to know that, because I don't know why he's at M.5 and if what the knees were at before they were at 50%. So you really we have to see a whole breakdown of the ratings to know where he would go, unless you know something I don't know, Ursula.
No, I agree. We'd have to see what was included in the aid and attendance and how those bumps got up. So unfortunately, that's not just something we can answer without seeing it. Okay, Michael Hawkins, 104, awarded TDIU permanent and total October 2010 due to lumbosacral strain with degenerative disc disease and lower extremity bilateral sciatica radiculopathy. Have a 21-2680 dated August 2012, January 2013, and September 2025. Denied aid and attendance in 2012, 2013, 25, and 2026. All denials stated favorable findings for aid and attendance. The 2015 denial became final. Filed BVA direct review in April of 2026. Did I wait for the BVA decision, or can I file a Q now with the regional office? My original file is flagged for hardship, and I filed an AOD and Williams waiver with the BVA. My ratings outside of the TDIU are 60% CAD, 50% mental health, 10% high blood pressure, SMCK, and pending claim for restless leg syndrome. My September 2025 rating increased my CAD from 10 to 60%, and my 50% mental health is new. If awarded 40% bilateral restless leg syndrome, what SMC tier can I qualify for? Thank you. So there's 2 questions in here, so I will take it one by one. Shannon, make sure that I'm tracking everything. Benji and Nate, can you go back to the first part of it? So the first question was, you currently have aid and attendance at the board. You filed all your waivers. You have a hardship expedite, and you want to know whether or not you can file a Q to those earlier decisions now. The quick answer to that is yes, you can. You can raise a Q at any point. So you can have things at the regional office, at the board, at the CAVC, wherever you want. If you want to assert a Q, you can do that at any point. So, but if your Q is that you want aid and attendance, I think you're going to be a little hard to get that Q for aid and attendance if you haven't even been granted aid and attendance now. So decide whether or not you want the aid and attendance now and then file the Q, or go ahead and file the Q. It really is your own kind of decision. But make sure that when you're asserting the Q, that you're hitting all of the right things. Like, you have to show that there was an error. You have to show that that error changed the outcome. And if they hadn't made that error, it would have been granted. The difficulty you're going to have here, just based on what I'm seeing, is they denied it in 2012. They denied it 4 times after, or 3 times after. So unless every single one of those decisions was a Q, you might have a hard time with that August 2012 decision. I'm not saying it's not doable, but just in my head, those are kind of the red flags that I'm seeing. So to answer your question, yes, you can file a Q at any point. Keep in mind, I know you said you're expedited for hardship. That expedite is good at the regional office. That same expedite does not work at the board. So you'll want to make sure that if you have severe financial issues, that you also file a motion to advance at the board for that. Okay, so that's the first part. Did I miss anything there?
No, I don't think so. The one thing that I would say about that Q, though, is, a lot of times people think an error is Q because it is a clear error to them. But but what Q means is that if VA went back in time and looked at that decision with only the evidence that was in the file at that time, is there any other way they could have made? Is there any other decision they could have made? So if it's arguable, it's not Q. It has to be based on the evidence at the time. There's nothing else they could have found. Q is a really high standard. So I'm just, everything Ursula said about it is right. I just wanted to add that point that it's really hard to get that. It's a high level of error.
It is. All right, so let's go to this. I think go to number 404. Go to 404. Okay. All right, no, just kidding. Go back to 304. Oh, you did file the AOD. Okay, good. My ratings outside of TDIU. So you have TDIU, 60. Okay. So you're probably, yep. Okay. Next one. Okay. So what you're asking is, if you are to get aid and attendance, what would your SMC tier be? It looks like based on this, you should already be at SMCS. If you're TDIU for just the back conditions, and then you've got the CAD at 60%, that's at least an SMCS right there. So SMCS is what it's called housebound, but it doesn't mean that you're housebound. It's just kind of the same rule. Essentially, if you are 100%, which is the TDIU, and then the remainder of your disabilities equals 60%, that's SMCS. So you should be eligible for that. Now, whether or not you get aid and attendance, if you get aid and attendance, that will take you to L. But based on what they say you need that aid and attendance for, you could then be looking at additional half steps, depending on how it's categorized and what your ratings are. You won't know that until you see what that aid and attendance is based on, if it gets granted. So I think, given this, if you're rated at 60% for the CAD, I think you're looking at SMCS with the K. If you get the L, you might be eligible for more, depending on how it's categorized.
I agree. Okay, this one's from Hurry Up and Wait. Rated 0% for sinusitis, rhinitis based on CMP x-rays. Recently, an ENT ordered a CT scan showing mild, moderate, chronic ethmoid sinus disease. I've been prescribed medication and nasal spray, and we'll be starting allergy shots. I haven't had frequent doctor visits because my primary care told me to manage it with over-the-counter meds and saline, since there wasn't much else they could do. is this ENT info enough to file for an increased rating now or in the future, or do I still require to go each time to my PCP for each issue in the year for documentation purposes? I will say, I always recommend getting things documented. Just the more, and I know it can be annoying. I'm not saying go for unnecessary doctor visits, but you got to go to your primary care anyway. Keep talking about the fact that you're having these sinus problems. I don't know how much blockage did the X-rays show. Can you go back to one more?
I don't think it said.
It said showing mild, moderate, chronic sinus disease. So the way the sinusitis and rhinitis is based is one, how debilitating this is as far as like, are you having to go to the doctor? Are you hospitalized for this? What kind of medications you're taking? And then how much blockage there actually is. I think there's a rating for, 50% blockage or, yeah. So I don't know that shows that. Mild to moderate sinus disease, I'd want to see the CT scan, I guess, and see what it shows actually about how much blockage there is and whether it gives you a percentage on that. But you can look at the rating criteria, and I don't know what medication you're taking. I think, I believe I know the skin is based on steroid usage. I think it's how often you're having to use it and what medication that is. So, the thing is, I always would recommend go ahead and file for that increase. I don't know exactly what you've got going on here, but that sounds bad, and it doesn't sound 0%. It sounds like you're more debilitated than a 0%. I'd go ahead and file it and let them figure it out. They can't reduce a 0%. There's no real reason not to go ahead and file that. I would file it. Ursula, do you have any other opinion?
No, the only thing is, as far as like going to the ENT and then showing up to your primary care physician just to document it, you can document this stuff by just submitting those ENT orders to VA. Yes. You don't necessarily need to memorialize it by visiting a VA doctor. So when you file for that increase, just file those medical records along with your claim, and that should be good enough. All right, Chris, 1975, one of three. I filed a 10182 almost a year ago, and the board has never docketed it. Any advice? Okay, so I'll stop right there. So the docketing letter should come fairly soon after, I would say maybe a month or so after you file that appeal. And it's going to be a letter that says we've, placed your appeal on the docket. The advice that I would give you is follow up with the board and the regional office, probably more the board, and say, hey, I sent this in. It hasn't been docketed. What can I do? And show them where it was submitted, because they need to get it pending. And I would just keep emailing them until they're able to get it pending. If you're within the 1 year, just go ahead and file it again as well, just to triple check yourself and make sure that it does get docketed, so that you don't have to fight down the line dealing with VA and being like, well, I submitted it. And they're like, no, you didn't. There's nothing there. You can argue other things along the lines, but try to get that appeal in, even if you do need to resubmit it. I feared it was not before the board because it's for aid and attendance. Aid and attendance, but they cited aid and attendance form in the decision denying SMCS and do not state the criteria for aid and attendance, but only say housebound denied. Had a Vera today, and RO confirmed that it is before the board, and I'm thinking of a pro se writ form and citing that. I believe I heard in a CAVC online hearing that statements are binding from VA. So I think you're trying to make a bigger argument than it needs to be based on all of that. If what you're saying is you got a decision and the decision denied housebound, and you're appealing aid and attendance to the board, you would have gotten some kind of letter saying, we can't docket this. because those issues haven't been addressed or they're on appeal somewhere else. But you're not going to just not get anything. And if you're in the situation where you filed it and you haven't gotten anything and they have not docketed it and they haven't said, we can't process this, then you do need to refile and try to get everything going. If the regional office told you that that is at the board, you can say, well, that's binding or whatever. Just call the board, shoot them an email and go, hey, is this pending? Why is it not pending? There's no reason to go into big arguments about, you know, it's binding. They told me this. Just call and see if it's at the board. Now, if your 1 year appeal time has lapsed, you're going to have a little bit more of a fight on your hand. Then you can kind of bring in some of that stuff. But first, just see if it's there. Send them an email. If they came back and said, we can't accept this because this hasn't been decided or it's still pending at the regional office, that's different. That then means that you need to handle that with the regional office before you can appeal it to the board. So I hope that's helpful, but just call them, see what's going on. Be like, hey, where's my stuff? It'll be easier.
Okay, this next one is from Catherine McDaniel. I'm currently receiving SMCL for 100% PTSD and recently received 100% for cardio and 50% for OSA, sleep apnea. Should SMC be M or M.5? I then received another, well, hold on. Okay, so you're L for PTSD and then you got another 100 and a 50. So that bumps you up one step to M, right?
So yes and no, because here you're dealing with half steps and full steps.
Right.
And what we don't know from Barry is whether or not you can take a full step and a half step at the same time. It seems like there's some case law out there that says yes. I'm going to argue it.
I'm arguing for 1.5. Yeah, I know.
Right.
I know what you're saying. Yeah. So possibly. It's still not a firm legal issue at this point. It's still being argued. Okay. Then received another 60% VA math. What should SMC be? What is the other 60%? VSO could not answer. I'm not sure. I can't either. Would you get another? Go back. Then got another 60%.
Yeah, I wonder if that's for a different disability completely, or if it's multiple other ones that equal 60%. Maybe that's what they're saying.
It feels like, yeah, that I think you still have the same issue there with your argument about full steps and half steps, don't you? Whether that's gonna.
Yeah. I mean, the way I look at this, so if it was just, you can definitely get to M two ways. You can get there through the 100% for the cardio, which is a full step, or you can get to M through a half step for the cardio and a half step for the sleep apnea. So I think you're at M. If you have another 60% combined using half steps, you would be at M.5, right? What we don't know is whether you can take that 100% for a full step, then a half step, then a half step, because then you would be at N. So I think you're at least at M.5 doing half steps for everything. Sorry, I didn't mean to jump in on this one.
No, I'm glad you did. I'm just trying to figure out, because then my mind's racing ahead to, okay, you've got an aid in attendance for PTSD. Should you also have an aid in attendance for cardio, sleep apnea, and whatever that other 60% is, then you'd have two L's, which is an O. So, I mean, I think
an O with the need for aid in attendance is an R1.
So you possibly could go up from that. I'm kind of wondering if you what disabilities, like what functional problems you're having from the cardio, sleep apnea, and your other 60%, and whether those would be another L. If you need aid in attendance for those outside of the PTSD need for aid in attendance. So you definitely need to go up. I would look at that as well. So, okay.
That is some solid advice, Shannon. Go look for an L in your other disabilities. And if you can get two L's, like she said, you go to O. O with the need for aid and attendance, doesn't matter where it comes from, gives you R1.
So there's definitely room to go up there. So I would be looking at doing that. If you have an SMCL now, you should be higher than that. Definitely going up.
That's a good question. All right, James. Have you all ever seen tremors, vertigo, and functional neurological disorder rated? They are more tied to TBI or PTSD. I am not TBI connected yet, scheduled in September for TBI exam. I am already 100% permanent and total. I'm looking to make sure they do not combine TBI and PTSD. Back to the first part. First part, okay. So yes, I mean, I've seen tremors, vertigo, and neurological disorders rated. The tremors are usually going to be rated by whatever extremity or body part is affected. We see that a lot in Parkinson's or Parkinsonisms. It's, tremors, that's how they're rated. So yes, we've seen those. There is a rating code for that. Vertigo, I've seen multiple ways. I've seen it through hearing loss, Meniere's, depending, also rateable. And then the neurological disorders, this is where I think you're kind of on the right thing, saying you're trying to make sure the TBI and the PTSD isn't rated together. So the neurological disorders, a lot of times VA is going to take those and they're going to rate them based on the mental disorders rating schedule. So they're going to look at functional impairments due to concentration, all that stuff. And it sounds like so there's that's going to be more of the behavioral issues, but there's also limitations when it comes into cognitive abilities. And sometimes there is an overlap when it comes to the cognitive and the behavioral that you have in these neurological type things. And you can't be rated, if you're rated at 100% for the mental health, and part of that is because of the memory loss, they're not then going to rate you on this side for memory loss. You got to kind of pick one or the other. And they do need to pick where it's most affected. So if it's from the TBI, it is extremely difficult. Well, it's not difficult, but you have to very much lay this out very cleanly and clearly. And typically, I would say with a doctor that is well versed in TBIs and mental health, because they can say, all right, these things are clearly mental health related. The unprovoked violence, the this, the that is because of a mental health issue, whereas these are different and they're not the same. And they're not the same because of this. And it can be very, very complicated. Those have been some of the more complicated cases that I've worked, is trying to maintain the separation of mental health symptoms and neurological issues that are coming with things. So, you may want to look at getting someone involved, make sure that you've got an expert that can do that. And then also just look at it and see if it's worth keeping everything separate. If you're not going to get anything extra by going through all this work to separate things out, it may not be worth it. If it's going to drop your PTSD down to 30 and then give you a TBI at 70, if you're already at 100%, so it doesn't, you got to look at what those ratings are anyway. So I hope I answered your question. And Shannon, please jump in. Please do.
No, I think you're right. It is very, very difficult to separate the behavioral part of TBI from mental health. So, but it sounds like you have a lot of physical issues from the TBI, and those are the ones that are easier to get rated. So if they do admit that you had a TBI and you've got tremors and vertigo and I don't know what the effects of your functional neurological disorder are, but if it's you have trouble with your balance and those kind of things are not as hard to separate out. But Ursula's right about the mental health and behavioral issues. They do overlap, and so you're not going to get both. But what you've listed here, and things like migraines and tinnitus that also come along with TBI, those physical manifestations of it are easier. Okay, the next question is from John C. Browner. I am 100% disabled Vietnam veteran. I am rated at 100% permanent. Will my wife get benefits? If I apply for these additional issues, is it possible that I can lose my rating? I have other issues that could be notated in my record. I understand it will not increase my rating, but should I go ahead and inform the VA of these issues? Depends what they are. So if it's like things, okay, first of all, let me go back to the first question, which was, can your wife get benefits? So there's a couple of different ways that a surviving spouse gets what they call DIC benefits, dependency indemnity compensation. One, if you're at 100% for 10 years. So I don't know how long your 100% has been in place, but if it's been 10 years, then it doesn't matter what your cause of death is, your wife would be entitled to DIC benefits. Please tell her she has to apply for those. They don't just give them to you. But if she applies and you've been 100% for 10 years, that should be a gimme. Now, if you have not been 100% for 10 years, then it matters what your cause of death is, and it needs to be service connected. So I don't know what you're 100% for. And if those conditions are the ones likely to be your cause of death. So if it's things like heart disease and diabetes and hypertension, then you probably don't need to file things like skin conditions and tinnitus and minor little issues like that. But if these are big issues that you could be service connected for, that could be part of your cause of death or something, or could impact that, it might be worth filing them. So it really just kind of, what I don't know is what those conditions are that you're already service connected for and what conditions you're considering filing. I would really need to know both of those to give you a definitive answer, but I think I explained as much as I can.
Yep. Combat Vet 09, thank you for all you do. You're very welcome. Yay! I used your information over the last 6 months and my VSOs help to get my SMCT approved with 2 years back pays. Y'all are awesome. God bless. Congratulations. Yeah, good job. Does that count, Shannon, as mine? Or
yeah, it counts. It's
okay.
Fine. This next question is from James G. How does hypertension diagnosis at under 40 matter? I was in aircraft maintenance and postal and deployed twice. My wife makes sure I eat healthy. Does it contribute to SMC in any way? I'm already 100% permanent in total. When having a private doctor and VA doc both complete the 21-2680 for aid and attendance, can I list things diagnosed and not service connected, diagnosed with vertigo and tremors, however not connected? Do not list those. Your aid and attendance has to be needed for service connected conditions. So only list the things that you're service connected for. And what was the first part of the question again? It was about hypertension. So if you're already at 100%, hypertension is probably going to give you a 0 or a 10. Now, hypertension is what we call a gateway diagnosis because it causes other things. As far as, the fact that you're under 40 may impact whether they think it's service related or not, based on, what kind of chemicals you're exposed to and things like that in your job. Aircraft maintenance, I'm assuming there were several. So whether they service connected or not, they will probably look at you're under 40 and you eat healthy and you're not, you don't have a weight problem, that those give weight to the fact that it was probably the chemicals, or at least, they don't weigh against you. As far as SMC, it's not really going to make that much difference because I almost never see a hypertension rating over 10%. They're usually 0, tops 10. So it's probably not going to change your rating in any way. But like I said, hypertension causes strokes, hypertension causes kidney problems, hypertension causes hypertensive heart disease. So it might be worth doing if there's other conditions that you have secondary to that. I think that's all I got. This one's you, Ursula. Oh, we lost your sound. I'll go ahead and do this one while we're getting Ursula back. Our question is from Kathy Hegler. My husband is suffering from chemical toxins that the VA just doesn't want to recognize because he drove the chemical truck in Okinawa. That's the whole question. Yeah, it's tough. Basically, I don't know if he knows what was in the truck he was driving. He should give a statement as far as what he thinks he might have been exposed to. If he knows anybody that he served with that might know what he was exposed to, that's a tough one. Now, I mean, it's hard to get VA to recognize something unless you have some evidence of it, and without evidence of it, you know, you're kind of relying on what he remembers, and you know, giving a statement about that. But yeah, that is a tough one. We got Ursula back.
Oh, I think I'm back.
You are back. We can hear you.
No, I can't hear you. Oh my gosh, what is going on here?
Well, this is your question. Okay, if Ursula can't hear me, I can go ahead and do the next question until she can figure out her.
Can you hear me?
Yes.
I can hear you. Okay.
This is your question.
All right. Thank you for the patience. You know, I was sitting here, then all of a sudden nothing's working. It makes no sense whatsoever. All right, Thomas, I was wondering if there are times when sleep apnea and asthma are allowed to be rated separate. So yes, well, kind of yes and kind of no, but yes, sometimes. So the way that this happens, and it doesn't happen all the time, is that they're not necessarily going to be rated separately. You'll still see them rated together, but there is part of the regulations that allows for a step up in the rating. So the way that you do this is, let's say you're on a CPAP and you've got, you know, really bad asthma ratings as well. And they come in and they're just like, yep, here you go, 50% because you're on a CPAP. But if your asthma ratings make it worse, there's this thing where you can step up in ratings. So you would maybe get a 60% for the two combined. I haven't done an argument like that in a while, so it's not super fresh in my head, but I do know that there is an argument for that. And the way to get a step up, if you read in the actual respiratory conditions rating schedule, it'll kind of tell you some of those things. But if you can essentially say, my sleep apnea causes these issues and my asthma causes these issues, and they are complete and separate, you can get a higher rating for them. But you're not going to see asthma 10% and sleep apnea at 50. I don't think. I think you just get one of them kind of bumped up. Shannon?
I agree. It's going to be sleep apnea with asthma or something like. They're going to give you one rating for it, but they almost always just give you the higher of the two ratings, and that's not exactly what the rating code says. So like Ursula said, look at the steps up.
I'll take another one because I was on. Okay. Great day, everyone. If you haven't read Matt's book, please don't forget to request your free copy. That's exactly right. Get the free copy. I think we're going to show a link at the end of this where there's a little thing. And I don't know if I shouldn't say, there might be another book of some sorts coming out at some point one day soon, maybe, but I don't know. And I'm not saying anything about it, but
it's in the works, perhaps.
Maybe. All right. All right. I'll do this one too. Okay. And then you're up next. Okay. If I submit a claim for sleep apnea secondary to GERD, will they look at all my connected disabilities? And also, can they redo my GERD from the grandfathered one to the new one? All my disability. Is there more?
Apparently not.
Is there more? Okay, so we'll just stop here. They should look at all of your disabilities for sleep apnea. What VA is supposed to do is when you file a claim and you're like, I have sleep apnea, they're supposed to look at all of the reasons you may have sleep apnea. Do they do that? No. Now, if you specifically say, I have sleep apnea second to GERD, then they will typically usually look at that and get medical opinions on that as well. But if you've got 45 or even 15 service-connected conditions and you say sleep apnea, they are not just going to on their own get medical opinions for every single one of your service-connected conditions to see if it causes sleep apnea. So give them a little bit of a hint on why you think that is. Now, as far as the GERD, so the way the rating schedule works is if you are grandfathered in and you have a rating, and then a new regulation comes out that is more favorable to you, VA is supposed to use the most favorable one. This also works if you have one rating and they change the rating schedule and the new rating schedule is terrible for you and you would be dropped down 20%, they have to keep you in the one that is most favorable to you. So they may try to change you, they may try to leave you, but just bring it to their attention that you need to be in the rating schedule that's most favorable. Sometimes it's staying where you are, sometimes it's getting under the new rating schedule.
Okay, let's see. This one is James G. I think this is the same James G. Have you ever seen urinary and bowel incontinence secondary to PTSD, IBS, or both? Also diagnosed with I never can say that, varicocele. Are these likely TBI residuals as well? How do I connect these things to service? I don't think that's TBI residual. Although I have had actually urinary incontinence as a TBI residual. I do have a veteran who has had that issue service connected, but it kind of went, it was not a straight path. That's all I'll say. So not necessarily, but if you have, so here's the thing. I'm not a doctor. Ursula's not a doctor. If your doctor says that's related to TBI, then I'm happy to be proven wrong on that. I think that's a real tough one to get service connected as a TBI residual, but it can happen. Have I seen it secondary to PTSD, IBS, or both? I have not. The bowel incontinence, yes, for IBS, not to PTSD, and urinary I have not seen related to IBS either. So how do I connect these things to service? The bowel incontinence, I would talk to your gastrointestinal doctor and see if he thinks it's related. I mean, you can ask them about any of these things. And if you're being treated for a TBI, I mean, ask the doctor, ask your neurologist, are these things related? Potentially they could be. What you need here to connect those things to service is a medical opinion saying that they are related to service. You know, I mean, I'm not a doctor, so I couldn't tell you for sure that in your case, I don't know what the rest of your medical history is, that those things aren't related. I think you'll have a real tough time connecting them to PTSD. IBS would be easier. What do you think, Ursula?
I think you did very well. All right, Jason Earhart. A current enlisted had mental health issues documented before enlisting, was told, don't tell anyone. Now possibly getting booted, married with twins. What should he do? Not this vet, but is Parkinson's service connectable? All right, so you got two questions here. I will take the first part first. So there are situations when someone enters the military that they had some kind of mental health treatment, issues, therapy, something like that. And if they just don't say anything at all during their things, I have seen, like during their enlistment physicals and histories and stuff, I have seen people get booted for a fraudulent enlistment, saying that you lied about these things. But typically what I see is there were no mental health issues at the beginning. And it depends on the situation and how it all happens, because I've seen this go kind of a couple of ways. Sometimes if you go to therapy when you're 16 years old because you're having a crisis because your girlfriend broke up with you or whatever, that doesn't necessarily mean that you have this like long-term mental health disorder, something that's going to be chronic. That could be something that was just you had to deal with it, you went and saw a therapist, which is different than you have severe bipolar and you know about it and you then go into the military and you don't tell them anything. Those are two different situations, both with mental health issues before. And I think it depends on what's going on, because there are a couple of laws that we can add to whether or not we knew that there was a mental health issue, or whether or not something kind of happened in service that could have caused this manifestation of this health issue. So there are things you can do, but it depends, and you may want to have someone look at it. There's not enough information here. People get booted from the military all the time because of their mental health issues. Sometimes it's mental health issues that were caused by the military. Sometimes they're mental health issues that naturally manifest at 23, 24 years old that are still able to get service connected. So it depends. And I know it's a very horrible lawyer thing to say, but it depends. I think he should probably talk to someone, maybe not a VA attorney just yet, but if he's going to get booted, he's going to get booted, but try to make sure that his discharge is good enough to where he could get the benefits after. So that's with that. As far as Parkinson's, yes, it depends on, again, it depends. Parkinson's can be service connected in a lot of different ways, especially for people that had certain types of jobs or served in certain places. Not a lot, but Parkinson's is not a disease that is uncommon in our practice for us to see and understand how it is service connectable and what causes Parkinson's in some of our clients. So I would say that yes, it is very service connectable, just depending on what the facts say inside the service records.
Can I address the mental health issue real quick?
I would love that.
Okay. So if he didn't report it when he came into service, what you haven't said here is whether they know he had a problem before service at this point. Because if there's no record of it and he didn't tell anybody, and they don't have actual documents showing a mental health diagnosis prior to service, veterans get what is called a presumption of soundness. When you enter service, they have to presume that you are healthy unless there's some reason to think that you are not. So if it's not on his entrance exam and it's not a problem anywhere, he gets a presumption of soundness. That can be overcome by records showing that he had a problem prior to service, etc. Even if that happens, though, there's also a presumption of aggravation. So if he had a problem prior to service and it got worse during service, or something happened to him, so maybe he went to therapy one time before service and then bad stuff happened to him in service and it became he did 3 years with no problems and then something happened and all of a sudden now he's got major mental health problems, tried to kill himself or whatever. That looks to me like the problem is worse than the one he had before service, and that's aggravation. So there are still ways to get that service connected, even if he had a problem prior to service. So just keep in mind that, they have to assume you were okay unless they can prove that you weren't. So that's all I got on that.
Yeah, and sometimes I've seen where they don't say anything, but then when they're in, they're like, yeah, they get, sent to the psych doctor and they're like, yeah, I was in therapy for 6 months. Like they kind of telling themselves in service. And that's when they start dealing with like the discharges and discharges for, that aren't honorable or under honorable or whatever. So it just depends. He's probably going to need someone to look at that just to.
Agreed. Okay, this one is the Veterans Aid. We have a BVA remand that has been sitting in the national queue for 69 days. Is this time frame normal? Is there anything that can be done to move this along, or are we at the mercy of the process? So the VA is supposed to expedite a case that's coming back down from the board. if they're not doing it, there's a couple of things that you can do. 69 days is not completely out of the realm of reasonable. It depends what the BVA remand said. If they remanded it for exams, it can take a while to get those exams, but if nobody's even looked at it for 69 days, then I feel like it's fallen through the cracks a little bit. You can contact the board, the chairman of the board, and directly, go that route and say, you've remanded this case and nothing's happening with it. And I have had some success getting them to jump on that and follow up with the regional office level and kind of say, why aren't you dealing with this? You're supposed to. So you can take that route. You can also go to go through the regional office or the DROC and go that route and kind of push them on it. But if it's sitting there and nobody's done anything with it for 69 days, then I would be reaching out to someone on that. If, however, it was sent back for exams and somebody looked at it and then, punted it for exams, or they requested some records that they don't have yet, then 69 days isn't unreasonable. So it kind of depends if they've done anything with it or not. If they have not done anything, then I would be reaching out to someone to try to push that along.
All right, this is from James. Can you qualify for PTSD aid and attendance with a 70% with evidence? I have a police report with multiple ER visits showing the severity, already 100% permanent in total. The quick answer is yes, you can get aid and attendance with a 70% rating. What I will say is that if you ask for aid and attendance on a 70% rating, I am almost guarantee that VA is going to send you a decision denying it because you're not 100%, and then put a favorable finding that you need aid and attendance, because we see that every single day. But it's not true. You don't have to be 100% in order to get aid and attendance. What it means, and especially in the world of mental health and aid and attendance, is whether or not you need regular aid and attendance from a person due to your mental health disorder. These can be things like medication management. People always run for the, I left on the stove one time. That's not always going to be enough for aid and attendance, leaving the stove on one time. But if you have multiple police reports and ER visits because you are severely depressed, going off the handle, suicidal, you may need that aid and attendance of someone to keep you safe in your community, to make sure that those police do get called when something happens, that you are going to the ER when you need to, when things are getting so bad. So yes, you can absolutely get aid and attendance for things like that.
Okay, this one is for VB Consulting. Once you receive notice from the board that your appeal is remanded to the regional office, can you appeal to CAVC, or do you have to wait for the RO's notice? What if the RO separates their decision and you miss the deadline? So if you get a decision from the board that they're remanding your appeal, that is not a final decision and you cannot appeal that to the court. So you have to wait for the regional office to make a decision on that before you can appeal that decision. If the RO, I don't know what you mean by separates their decision, but you haven't missed it. I mean, if you got two issues that are remanded and they decide one and not the other one, you have to go ahead and appeal that one they decided. You can miss the deadline that way. So if they separate out different issues, every rating decision needs to be appealed. I hope that answers your question.
Solid love. I have my C file on CD. Are there documents on the disk in the order that they were entered into my file? Yes, they are. I'm trying to determine whether a record was part of my claim when I originally claimed it. So yes, it is exactly that way. And that's a way that I know I look at C files to see what things were in the file at what time. The best way to do it is, so look at the most recent thing and then the very first thing that's in there. So for us, we look, all the way to the back, and I look at see if there's a claim. Then I see the decision to that claim. and I look at what was in the record at that time. If there are more records or anything that comes after that decision, that does mean that those were entered after. If you're opening up your PDF, you can look at your bookmarks and, you know, it'll kind of have everything kind of labeled there. But that's exactly how you check to see what was in the file when your decisions were made. Don't go by what they say on the rating decision is listed in evidence, because that's not accurate. Look at what was actually there.
Okay, this is from Daniel Johnson. Why does the VA deny claims and make you appeal? Woo, if I knew the answer to that one. Yeah. I have a lot of snarky answers that I want to give right now, and I'm holding them in. But I would say, I mean, sometimes they deny because they don't understand what's happening. Sometimes they deny because you're not entitled to benefits for something. I mean, sometimes they're right on that, and you don't get benefits for everything. You know, if your condition isn't related to service, which, believe it or not, I see veterans do that all the time. They'll tell me they filed for something just because. I had I asked, were you diagnosed with that? And they'll tell me no. I'm like, well, then probably they're not going to grant that. It could be because you don't have a current diagnosis. It could be because your records aren't complete from service. It could be because you don't have a nexus connecting the service. I mean, there's so many reasons they deny. Sometimes they're right. I would say very often they're not. You know, I don't think it's malicious. I think it's more the product of a broken system. They're overworked. They don't have time to review a whole file. They have a certain number of decisions they got to get out, and they're just boom, boom, boom. They don't have time to review the file. That's why you got to do it. You have to get a copy of your file. You need to go through and see what's in there and what's not in there. You need to look at why they say they denied and whether that's a valid reason or not. I wish I had a better answer for you, but yeah, that's kind of a loaded question there.
I think you said that nicer than I would have and much more eloquently. So we'll leave it with that one. We'll leave it with that.
You see the steam coming out of my ears?
Yeah. All right, Jordan Brown, what are your thoughts on veterans choosing to work with an attorney or a VSO? So, you know, I think it comes down to a personal choice, number one, but also just the complexity of what is going on. So VSOs are a wonderful resource. You're going in and you want to file a claim, and it's pretty easy to kind of see what that connection was. You are a parachutist, you blew your knee out, you're trying to get that service connected. You have heart disease and you were in Vietnam, and there's no question about that, and they're going to get that service connected. Those types of things, they are wonderful for, even if your claim is a little bit more complicated, to help you file that initial claim to make sure that everything is in the file. I think that VSOs do a wonderful job. When you're getting into some of the nitty-gritty and the things that Shannon and I work on, I would not go to a VSO for those. I think, but not every claim, like we don't see every single claim that was ever out there. You know, the ones that are easy, those are typically getting service connected. We're seeing the ones that are very difficult. They're hard to prove, or, you know, they need an attorney to look at them, and that's why they're here with us. But I don't have, you know, when I look in a file with someone who came from a VSO, sometimes VSOs do a really good job. I've also seen VSOs not do a good job. I've seen them miss deadlines. I've seen them not appeal things that were on appeal for 8 years, and they just decided not to do it anymore. They don't have the same resources available to them when it comes to the doctors and the experts. When you're paying an attorney to look at your thing, you're also paying for their network of providers that work with them. So the different experts, you're not going to get those with the VSOs. So I think, you know, it comes down to choice. It comes down with, you know, what your comfort level is. If you just kind of want to get through it, you want the VSO to do it, great. You know, we are certainly, I think, a little more motivated to start looking back at your claims and what's available and are there mistakes and things like that, because we get paid on the retro, and that's how we get our money. So we want to look and see what things have been left and things that are missed out on the table. And I don't think VSOs do that either. But Shannon, your thoughts?
Yeah, I think it comes down to, a veteran service officer is not going to charge you. And so if you have a case that you can win without needing an attorney, then you should do that, or if you can do, quite frankly, you can do it yourself. If it's a case that's pretty straightforward and you understand it and you have a doctor that's supportive, you may not need an attorney. If you're not happy with the decision you're getting, then maybe have somebody else take a look at it. I agree. It is just kind of, what you're comfortable with. So I think we have time for about 2 more questions.
Okay.
All right. This one, County VSO in North Carolina here. I love your chats. I use them as a work tool in continuing education. Thank you for your honest and accurate information. Thank you. We hope that we're helpful. That's the reason we do these. So I'm glad you're getting something out of them. You want me to do this one too, since that wasn't a question?
No, because you let me do the other one, even though I want you to take this one, but I'll do it. I'm filing for spinal stenosis. Do I file radiculopathy as secondary or just mention it to the CMP during exam? I would file it as secondary. Especially if it's not service connected, I would file for and just say, secondary radiculopathy. That's all you really need to say, but I would go ahead and put it in there. That way it's not missed. It's definitely there. They do address it. They have to address everything that you put in there now. So, but let's say you didn't file for it and you mentioned it to the CMP exam and it's on there, then they should be addressing it too. But I think you have more of a chance of them missing it if you don't actually claim it. I would put it on there.
Yeah, you do not have to do it, but why not? If you haven't filed the claim already. Now, if you've already filed for your back, I don't know that I would go ahead and file radiculopathy before they make a decision, because then they're going to give you that effective date and it's a chance for them to mess it up. But if you're just now filing for your back, yes, add the radiculopathy with it. There's no reason not to.
All right. So I think we're all done here. We are so glad that we got to spend some time with you. I think we got through a lot of questions and that was really exciting.
Someone will be back next week to answer your questions, and thank you for your service.
Bye.
You served your country, and now another challenge awaits. Getting the VA disability benefits you've earned. Too many veterans face endless delays and denials, and they shouldn't have to. At Hill & Ponton, we know the system and how to fight for you. Scan now to download The Road to VA Compensation Benefits, a free guide from Hill & Ponton, trusted VA disability attorneys. For over 30 years, we've helped veterans secure the benefits they deserve. Our free guide helps you avoid common mistakes and know when to call for backup. Scan now or visit hillandponton.com.